Good morning, Your Honor. Glenn McCandless on behalf of defendants John O'Leary and Bonnie O'Leary.
Good morning, Your Honor. Brandon O'Leary, plaintiff.
Anyone else appearing on these?
No, Your Honor, these are the only two parties left. There's John O'Leary, Bonnie,
All right,
and
and
Bonnie O'Leary.
what motion do we have, Madam Clerk?
Judge, it's actually not a motion. Looks like there was an opinion and an order dated 5/29/25, setting today's hearing regarding a default judgment that needs to be entered.
Oh, that's correct. All right, so go ahead, defense counsel, with
Your
your
Honor,
request.
Your Honor, there's not been a good cause or meritorious defense in any way shown. These Mr. Brandon O'Leary's claims have been shown to be false and lies. Default has been entered. The request was for a default judgment was made.
Counsel, let me interrupt you. So I know a default was entered. I basically entered it with the opinion and order. This is a hearing for entry of a default judgment as to damages. So if you want to be heard as to damages, do that.
Yes, Your Honor. We're requesting $75,000 in damages, $25,000 each claim. Mr. O'Leary's made numerous slanderous, defamatory, and libelous allegations against his father and his grandmother. They're prepared to testify, and his claims have been. If you reverse engineer his claims, we've shown them to be false and fabricated. Mr. O'Leary's indicated he uses AI to come up with his arguments and allegations. He also impugned the sheriff and several other people.
Action, Your Honor. Attorney misconduct. He's again misleading the court and fabricating.
Objections overruled. This is argument, Mr. O'Leary. He's going to finish his argument, then you can say whatever you want. All right. I understand your argument, Mr. McCandless. What's your response, Mr. O'Leary?
Good morning, Your Honor. I respectfully ask that this court allow me to present my full verbal argument for the record. I'm a pro se plaintiff pursuing justice in a complex and traumatic matter under MCR 2.603D1.
Well, Mr. O'Leary, we're here on a specific motion. It's a motion for entry of a default judgment. That's the issue we're going to hear this morning. We're not going to litigate issues I already decided or heard. So with that, I will allow you to be heard as to his request for default judgment in the amount of $75,000. So go ahead.
Under MCR 2.603, the court has discretion to set aside this default in accordance with MCR 2.612. Michigan courts consistently disfavor defaults and strongly prefer adjudication on the merits. As the Court of Appeals explained in Shaw v. Spenceburroughs, procedural rules should not override substantive justice. Here, my defenses are meritorious. Truth is an absolute defense to defamation under MCL 600.2911. Everything that I've said about defendant John O'Leary is
Let me interrupt you for a moment. Madam Clerk, do we have a motion to set aside default up for today?
No, Judge, I don't have that up for
today.
Right.
So you should, if you thought that, you should have timely filed a motion to set aside default. Given your pro se status, I'm going to allow you to make that argument. So go ahead, even though it's procedurally incorrect, Mr. O'Leary.
Thank you, sir. Here, my defenses are meritorious. Truth is an absolute defense to defamation under MCL 600.2911. Everything I've said about defendant John O'Leary is supported by evidence, firsthand statements, and medical documentation in the pursuit of justice. Under Smith v. Anonymous Joint Enterprise, statements made to expose abuse and misconduct are protected by qualified privilege. Any reputational harm suffered by the defendant stems from their own misconduct, not my pursuit of truth and justice. See Ireland v. Edwards. The previous ruling did not fully consider my meritorious defenses, including the fact that I was chemically incapacitated and retaliated against for reporting my abuse in the past. And I've shown this court proof of my hospitalizations as a result of defendant's conduct, proof of injury as a result of defendant's conduct, and the psychological toll is evident. I'm not a lawyer. I'm doing my best to follow the law and the rules while surviving what I now understand was a cover-up. Finally, pro se litigants are entitled to some leniency. Haynes v. Kerner, the U.S. Supreme Court recognized that pro se filings are to be held to less stringent standards. Under MCR 2.603D1, a default may be set aside if the moving party shows good cause and a meritorious defense. Good cause, a legitimate reason for the failure to answer or otherwise defend. Some examples: a mistake, excusable neglect, or in some cases, a procedural confusion by a pro se party. As a pro se plaintiff, I made a good faith effort to respond, but was delayed due to procedural confusion and the overwhelming complexity of litigating this case on my own while coping with the severe trauma that I endured. This constitutes good cause under Michigan law, which recognizes that honest mistakes or excusable neglect, especially by self-represented parties, should not result in default. Michigan courts often accept confusion about court rules or not understanding procedures as good cause, as shown in Huggins v. McGen Insurance Corp., holding that an honest mistake and lack of legal training by self-represented parties warranted setting aside a default. Additionally, I've shown meritorious defenses, including truth, constitutional privilege, supported by firsthand evidence, hospitalization records, medical records, records from childhood, records of a severe condition that was caused by intense and repeated abuse. And this must be, supported by the evidence, right? It's not just general denials or conclusions. Like, everything that I've said is supported by evidence. So if allowed to proceed, the defenses that I presented could directly impact the outcome of this case. Therefore, the default should be set aside so the matter may be heard on its merits, as Michigan courts strongly prefer. See Elkin Ziegler Inc. versus Waterbury Headquarters Corp. MCL 600-5855 also is designed to protect victims where defendant's fraudulent concealment prevents timely legal action. Here, defendants are still actively concealing their own abuse. They've lied in sworn affidavits, and this alone justifies relief from default and equitable tolling. So in summary, I ask this court, do not let this case be decided on a default. Let it be decided on the truth and the merits with all of the evidence that I presented taken into account. I respectfully ask that the default be set aside under MCR 2.603D1 so that my defenses and claims may be fully heard and all of the evidence is taken into account. Thank you.
All right. With respect to defendant's oral motion to set aside the default, that motion's denied. The court does not believe that I misspoke. With respect to plaintiff's oral motion to set aside default, the court denies that motion. The court finds there is no good cause to do so. Plaintiff has not presented a meritorious defense, and the neglect in this case was not excusable. With respect to the default judgment request, are you asking for two judgments, one for each party, Mr. McCandless?
Judge, yes, we're requesting for yes, Your Honor, two judgments, one for each party. I'm sorry,
Judge. The court grants your motion. The default judgment will enter against plaintiff in the amount of $12,500 for each party, for a total of $25,000.
Okay, thank you, Your Honor.
Judge, and that order should close the case, correct?
Yes.
Yeah.
Thank you. Mr. McCandless, please submit that order